Welcome on this sunny, for the time being, Wednesday. My name's Julie Ban. I'm the employment partner here at Sharpe Pritchard, and I'm going to be contributing to this session later on as we go through. And it was really interesting to see the number of people that registered to join the session today. As we're covering TUPE, see there, back to basics, which shows that actually it doesn't matter how long you're involved in this sort of area, albeit from a legal perspective, HR or procurement. TUPE is always complicated every single time that you do it because there's so many grey areas. So we're going to try and look at, we will go back to basics and try and look at some of those issues and some sort of practical tips as we go along. We have had a few questions that have come through beforehand, so thank you very much for those people. I think what we'll do is leave them to the end. I think it makes more sense once we've gone through the information to do it then. And without saying any more, I'm going to hand you over to David, who's going to lead today. Thank you.
Thank you, Julie, and good morning, everyone. So yes, we're looking at the joyous thing that is TUPE. So next slide, please, Medina. We're going to cover today basically an overview of what TUPE is, and then mainly focus on service provision changes, as these are what we see as the majority of TUPE that we certainly advise on, and I think a lot of local authorities and other people who let contracts will certainly be involved in. We'll then be looking at some of the practical issues that might come around TUPE transfers, what you might want to do or consider, and gaps in the provision of the service, fragmentation, and then what we kind of call staged transfers in relation to TUPE, and then some key takeaways as well. So next slide, please. So basically, what is TUPE? It is the joyfully named Transfer of Undertakings Protection of Employment Regulations from 2006. And basically, it is there to protect employees' contracts of employment and transfer them from one employer to another as a result of a business transfer or a service provision change, to make sure that when these sorts of things happen, lots of employees are not left without a job going forward. So next slide. So what is a service provision change? Well, TUPE defines it as one of three certain things. It's an outsourcing. So you currently have a service within the organisation that you are then looking to effectively give to another company to do this for you. So you're sending that work out somewhere else. Insourcing, obviously, the reverse of that. You are trying to do this in-house again, and you're bringing the activities that were currently with a contractor back into your own systems. And then obviously a new contract, the primarily common situation we see, which is also called a second generation transfer. You've had a contractor, you've let the contract, and a new contractor has been appointed, and you're transferring the services to them. And just to the person who's just put the question, yes, we will be sending out the slides and a copy of the recording as well. So these will come out shortly after today. So how does TUPE operate really in these situations? So on a service provision change, you have what is called the automatic transfer principle. Employees who are assigned to an organised grouping have the legal right to transfer, and this will automatically happen. No one really needs to do anything. I think sometimes how I've described it to some clients is some magic happens overnight, that someone scribbles out the old name of the employer on the contract of employment and writes the new name in as the transfer happens. That's effectively what it is. And people transfer on their existing terms and conditions, subject to any measures which have been put in place or communicated beforehand to change those terms and conditions, and all those liabilities and rights carry over as well to the new employer. There are some oddities when it comes to occupational pension schemes, so many people will be aware, and certainly things like the New Deal and other elements which protect local government pension and other state pension, other civil service state pensions going forward, and admission agreements in relation to that. And the other thing is that it includes collective terms negotiated and agreed, whether by trade unions or between the employer and employees. These also transfer, effectively is becoming quite wide-ranging. It is in anything that derives from the contract of employment, i.e. you get it because you are employed. So for example, a couple of years ago now, there was case law about share schemes, and the tribunal did rule that the only reason this person was entitled to partake in a share scheme was because of their contract of employment. It flowed from the contract of employment, so it should have transferred, and the new employer should have operated something of a similar nature. So again, it's quite a wholesale lift and shift of people's rights and responsibilities that will transfer to the new employer. So it is something that people really do need to be aware of when you are getting contracts in, because obviously it could be fundamentally different in certain scenarios to how you treat your existing staff that you've hired on your own contracts of employment. So next slide, please. So how to know when TUPE is really going to apply, and certainly it is at the end of a contract, it may apply. It certainly shouldn't always be considered, well, the contract's coming to an end, we're letting a new contract, therefore it's always going to apply. I think that shouldn't be your starting point. It should always be, we need to look at this, is it going to apply? So I think the first thing really to be looking at is you've got an existing provider, or you're outsourcing and insourcing, and the activities that you're going to be doing post transfer date are fundamentally the same. And that is key, that the activities are going to be done, well, it's the same activities, they're fundamentally the same, and they're going to be carried out in a similar manner by the new provider or yourself. If there's substantial changes, if it's completely different, that can lead to not being fundamentally the same, and therefore TUPE transfer does not necessarily apply. Secondly, immediately before the transfer, there is an organised grouping of employees within the UK who has their principal purpose of carrying out the activities on behalf of the client, i.e. usually yourselves. This again can be quite the interesting point to be looking at, is what is this organised grouping? And as part of that organised grouping, and I think we are going on to that a bit more, is there's a conscious element to that organised grouping. And then immediately before the transfer, the activities will be carried out by the transferee, and there will not be a single specific or short-term duration. So, they are going to continue for a relatively longer period of time, and the client must stay the same. Now, again, this is something we're seeing more and more, certainly around certain like PFI and other contracts, where there's been changes of clients underlying in this that again may render a TUPE transfer not happening, because the actual client has changed throughout this situation. And obviously it's not for the supply of goods for your clients, Lucy, it's for services. So next slide, please. What is a relevant activity? And this is, like it says there, a question of facts and degree. They do not have to be identical, but they do generally have to remain essentially the same. And differences in delivery can take part. I have seen that in the past, where something has been operated in multiple different sites and then being condensed into one singular site, where the products, so it's catering, they were done in different sites, all brought in-house into one location, and the food was then basically sent out to the locations where the food was requested, rather than being cooked on site. And that potentially could be considered a fundamentally different activity, even though basically still providing food. The whole way the service was being done and run and structured was quite different. So again, that could have looked at being a fundamentally different way of providing these activities. You should be looking at the scope and volume of the activity. Is it basically the same? Is you're massively increasing in size and scope of the activities? Are you decreasing this? And again, this could be looking at things of which we'll go on to later on as well, lotting of big services. Previously people have had one contract to deal with everything. Going forward, they have then split them into individual lots, with lot one dealing with one specific set of activities, lot two dealing with another. And again, this has an impact on, are the activities fundamentally the same? And if the delivery model has fundamentally changed, you cannot identify where the current activities will take place afterwards. Again, you're looking at a scenario where the activities are unlikely to be fundamentally the same, so therefore TUPE will not apply. And again, it's just going back to all this, where each of these are a cumulative test. It's got to be all four of these tests that have to be met for a TUPE transfer to apply. It's not one, oh, we've got an organised grouping of people, therefore it transfers. the activities might remain the same, but you don't have an organised grouping of employees, well, then the transfer is not going to take place. Next slide, please. So organised grouping of employees, this is usually where we see a lot of the work needing to be done, a lot of the understanding both from our clients, the contract that's coming up, what the activity is going to be, all hang on organised grouping of employees. And as I should have said at the beginning, really, obviously, it's for employees only. So if there's workers, if there's self-employed contractors, if there's anyone who's not an employee as part of this scenario, they don't transfer. It only affects employees. So therefore, the group is employed and assigned to an organised grouping of resources of employees subject to the relevant transfer. Now, the critical thing here is there must have been some form of intentional organisation to deliver these services. If you just have a group of people that have kind of to a point coalesced and always seem to turn up, that might not be an organised group. But effectively, someone's going, well, we're going to have this contract and we're going to have the Sharpe Pritchard team are going to be created to service this contract for Sharpe Pritchard. There is an organised grouping of people to deal with the relevant activities that a contract has been let. So the principal purpose of that organised grouping should be to deliver the services to the client that has let the contract. This is the question of fact, and it will be the thing that the tribunal will dig into the most if you ever have claims in relation to a temporary transfer should or should not have happened. And it is a lot of factors. We always hear about the 50% rule of people's times. That is important, but it is not the be all and end all. It is very much of what is the scenario on the ground versus what the contract says. Has an organised grouping been created? And as it says there, that can be just one person. I know it said organised grouping of employees, but it certainly is and has been one person only has been organised to do this, and that one person themselves has transferred into the new employer. Next, please. There are some exceptions to TUPE transfer. So the general provision obviously sets there, must be an organised grouping with the principal purpose of carrying out the activities. So it's a single event activity. You're asking someone to do something very specific, and as it says there, conference or exhibition, and generally the scene examples, you want them to do one thing and one thing only. Even though there's an organised group, there isn't really going to be a transfer because it is short term. Or if this contract is specifically or wholly for providing supply of goods, it must include primarily a transfer of services and providing services. So moving on to the next slide, which is a bit more of the technical and practical side of managing a TUPE situation. So these are many things you have to really consider going forward, certainly if you are the employer of these scenarios. So certainly if an outsourcing scenario, what happens if you dismiss an employee doing the transfer? Is there any legal ramifications in that? There potentially could be, depending what the reason for the transfer is. Consultation is vitally important. You should be consulting with the people who will be affected by this TUPE transfer. So not only is that the people who are going to transfer out, it might be the people who are left behind. You need to consult with them as well. And transfer of information. So obviously that's the employee liability information, the ELI, measures, and making sure that you're given that information in good time, or giving the information in good time to allow people to have proper informed consultation. So moving on to your main duties, and we'll go back to the consulting and informing. These are two different things. Firstly, informing is providing the information. You then must consult with them and or their representatives who will be impacted by the transfer. Now, this is an ongoing duty. It's not a here's the first meeting and this is the transfer that's happening. There you go. Thank you very much. It's akin to a redundancy situation where it's an ongoing consultation piece with these people. You're providing the information. Measures might change. Also, you'll be feeding back. If you are the outsourcing or insourcing, you'll be feeding back, going, well, this is the consultation we've had. These are the things that have been raised, and it gets passed back. And that's potentially certain things on consulting on measures, what the impacts will be. So you'll receive a measures letter, or you'll provide a measures letter, and in that you'll be consulting with these people saying this is what it means, this is what's going to happen. I've looked at many measures letters in my career, and sometimes simple things that are left out and are very, very important. Change of pay date, that can have a huge impact on employees. Now, most people is the 29th of the month, or the end of the last banking day of the month, or the 25th of the month. That's not usually a huge change if it's, say, going from the 29th to the last banking day of the month. That's pretty much sometimes very close to being the same day. But if you're paid on the 15th of the month, for example, and you're moving to the end of the month to be paid, that could be a huge gap that employees need to understand and go forward and take part of and consult, because there might need to be further things that need to be put in place straight after the transfer that need to support these people. And again, changes to uniforms has been quite a big one I've seen. Changing to the employer name, it's anything you envision that will change on the day of transfer. And I have seen people forget simple things in measures letters, and it has to be advised to go back in, or otherwise people are suddenly going to forget, and you're in a problem that you haven't properly consulted with your employees. Next slide, please. So terminating employment and redundancy. I mean, redundancy post-transfer is, I think, sometimes goes hand in hand with some big contracts. But the main point is it's automatically unfair to dismiss an employee because of a transfer. So the reason you have dismissed someone is because of a transfer will be automatically unfair. And they will be bringing a tribunal claim for that. However, if you can show that the reason you've dismissed someone was for an ETO, so an economic, technological, or organizational reason that needed a change in the workforce, the dismissal will in and of itself not be automatically unfair. It can still be unfair if you fail to follow a proper process and procedure. It isn't I've got an ETO, I'm home safe and dry. You've still got to be going through these things, and it has to involve a change in the workplace. You can't just have an ETO, but it doesn't need to make a change to the workplace. It's not enough. It needs to be both. And again, you're going through your consultation periods, you're going through fair processes. So if here's a redundancy, you're going through your fair redundancy process, but you have the ETO on top, which has involved a change in the workplace. And having been involved in transfers in the past where someone says, can we just select everyone for the pool who's transferred in, and that's our pool to look at to make people redundant, that's a big red no, because you have selected someone because they have come in via a TUPE transfer. It will be automatically unfair. The pool does increase, and that is then when you're going to be talking to your other colleague or other employees who have been affected by the TUPE transfer, because they've gone from a pool of, say, 3 or 4 people to now, say, 7 or 8, 9, 10 people. But they're there, already, and suddenly they're at risk of redundancy because these new people have joined. It very much becomes, well, why am I being selected? There was not a problem until these people turned up. I hear that quite a lot, and unfortunately, that is the thing. If they are in the correct pool, they are suddenly in scope for redundancy because these people have transferred in because of a TUPE transfer. So again, these are some of the times that consultation, information, and working with employees and their representatives is critical, because you are going to get these people going, well, I've been here for years and suddenly now I'm at risk of redundancy because someone transferred in 2 weeks ago, or is going to transfer in 2 weeks, for example. That this is unfair. And if you're making redundancies pre-transfer, you need to be very careful as to whose reason it is and where the ETO comes from. You cannot borrow someone else's ETO. So post-transfer, if there would need to be a change in the workforce, that's fine for the new employer, but the old employer can't use that answer as their ETO. They must have their own ETO reason to make a redundancy, or again, there's no ETO, and the likelihood, the argument will be, well, you've selected someone for redundancy because of a coming transfer. And on this, employees can reject to transfer. Yes, it's an automatic principle, but that's basically the automatic thing is if the transfer happens, the transfer happens. Employees can reject to transfer, and they are dismissed because of that, because obviously their job moves to the new employer and they've rejected to go. They are generally dismissed from that. So it is just something, again, that people don't necessarily consider can happen, but it is there. Next slide, please. Yes, Julie.
Yeah, can I just come in on that? I think it's really sort of a really technical argument in terms of So your employees have the right to automatically transfer, but they can choose not to do so, because obviously they can decide who they want to be employed by. You know, that's their ultimate choice. But there are certain sets, so their employment just comes to an end. So you don't have to, you don't have to make them redundant. It's their decision. Their employment comes to an end, and that's fine. However, there are some limited circumstances where they can argue that they have rejected the transfer because of the transfer would result in sort of a material detriment to them. And if that happens and the tribunal are persuaded of it, then they are considered dismissed by reason of the transfer. So there's no straightforward answer to that, really, and it all ends up being up for debate. So I just thought I'd add that in. We don't want to go into any detail on that because we couldn't possibly cover all these things in any detail. Just wanted to flag it.
No, that's brilliant. Thank you. And just while we're on that, I've noticed that questions have been coming in. We'll probably be looking at most of the questions at the end. So thank you for those that put them in so far. And then, yes, it's basically just explaining a bit further there what I've already talked to. Businesses and people do make redundancies, but basically when there's a transfer going on, you need to be careful that you're not just making redundancies because of the transfer in and of itself, because again, that can just lead to automatically unfair dismissal claims, because people will be trying to say that they've been made redundant because of the transfer and there's no ETO provided. So next slide, please. So practical issues on TUPE, as Julie said, and we're all saying here, TUPE is not straightforward. Normally it is quite complex. Facts are usually quite complex as well. So, it is things to be looking at when you're looking at this. And I think the starting point really is to be saying, don't just assume a TUPE transfer is going to happen because you're ending a contract and you're reletting it, but also don't assume that TUPE transfer is not going to happen as well. People have been caught out both ways on that. So I think it's every time you're looking to let a contract, do turn your mind to a TUPE provision, and if it's going to happen. And I think as we're going to go on to some of these other things as well, but again, looking at your contracts, is the contract that you've are going to let, is it going to be helpful for you in 6 to 7 years time when the contract's coming to an end, to get information ready and to go from there, to providing ELI, how are your indemnities fine, are all these sorts of technical procurement and other contractual issues there really can impact on what you're doing when you're coming to a TUPE transfer. And as we said there, the three most common issues we really have are gaps in services being provided. When does that impact on a TUPE transfer? Fragmentation of contracts and services, and then this thing that we're calling a stage transfer. So next slide is just a short one on gaps in provision of services. So you might have it that you're bringing a contract to an end. You are planning to bring it back out, but you're not going to be doing it straight away. Your contract A ends on, say, 1st of January, and then there's nothing for a while, and then you're bringing a new contract out. That in and of itself does not always mean that a TUPE transfer is not going to happen. So a temporary cessation, like it says there, does not preclude a transfer, but it's something you need to be looking at. What is the purpose, nature and length of that cessation? So it could be, for example, you're running things term time. For schools, you've got the summer holidays coming up. So I know it's January, but you've got the summer holidays coming up, and there's going to be that gap, and then they're starting again. A new service provider is going to be starting in the academic year. The nature of that might mean a transfer might happen, because even though there's a gap of several months, this is nature of what you do with coming to that might be part of it. Small gaps might work and bigger gaps might not. It is something that's going to be very fact specific, and whether the organised grouping has continued to effectively sit there in existence waiting for the new contract to start are all going to be important things. I mean, we could probably do an hour on gaps in provision provision of services as well. And on a lot of this, it is things that are happening. So I think it's the sense of if you are going to have a gap, it's really something you should be taking advice on, because it could catch you out. That you do a couple of months later, you think you're all in the clear, and suddenly all these people are raising their hands going, I should have transferred, why haven't I transferred, I wasn't consulted. So it's just something to be keenly aware of. So we're now going to move into fragmentation and how that happens and when it occurs, and I'm going to pass over to Julie.
Thank you, David. I think this might be a good time to look at a couple of these questions because they relate to issues that have come up. So if I could just do that briefly. So the first one, a client is changing contractor but would like to lose a cleaning supervisor and absorb their role. Does TUPE apply? Well, yes. So if the service that is being provided is a cleaning service, and that cleaning service will continue after the transfer, or be in-house or externally, then, and the current provider has an organised group of individuals that are assigned to this particular contract, then TUPE will apply. What you're discussing here is that you're going to change how you provide that service after the transfer, and if there's no longer going to be a requirement for the cleaning supervisor and that's going to be absorbed into a role, that's a potential redundancy situation, and it will be your client who's responsible for making that person redundant because it is their redundancy situation, not the outgoing contractor, and the issues in terms of redundancy in TUPE that David have already covered would come in. In terms of who is covered by TUPE, so who transfers, the definition of employee under TUPE is slightly wider than it is under other sort of employment rights, and it covers people working under a contract of service. And so if you've got bank staff, it may, and they've been there for over 4 years, so they've worked regularly, then there will be an argument that they should transfer, because I think let me just see, the definition is it's something really vague. It applies to employees employed under a contract of employment, but it says something like or otherwise. So there's this sort of vague sort of scenario that would potentially cover workers. So it could well cover bank staff, but what they would do is they'd transfer with their same terms and conditions that they do have now. So they would remain bank staff, which would mean that the incoming provider would have the same rights to use them or not use them as they currently have. I would be slightly concerned if you have bank staff over 4 years that have worked regularly, week in, week out, that they're actually probably part-time staff, and you need to consider that, because just because you put them in a certain bracket doesn't mean to say that they actually currently are, but that's something else to consider. I think I don't know if we're going to have time to cover issues in terms of pension, but we might do that at the end if we can.
I'll just quickly pop in saying with pensions in themselves don't always transfer. These fantastic little things called Beckman liabilities, which again can be massively complex in relation to life benefits. So I would certainly say specific advice could be doing that. But when you're dealing with local government pensions, NHS pensions, and things like that, under the new fair deal, is they must offer either be admitted bodies and they maintain their they become a part of that LGPS, for example, and those transferring under that will transfer, or they must offer a broadly comparable scheme. And the broadly comparable scheme must be approved by an actuary. It's not someone that can just go, oh yes, here's our broadly comparable scheme, and you say that's fine. It must have actuarial approval. And certainly in the LGPS that is set out. And I think just on that, I've only seen once that someone has been able to have a broadly comparable scheme. Most of the time they'll just become admitted bodies for the length of the contract, and there will be an admission agreement on the side.
Fab, thank you. And the next question, I think I'm going to cover in one of the examples of quandaries that have come up, and this is a specific issue. So fragmentation occurs a lot in terms of local government outsourcing, but this issue in terms of actually getting realistic TUPE information is a real bugbear of mine. So I will cover that, but I think it comes up in the slides anyway, so bear with us on that one. Transfer existing terms 36 hours transfer or 35 hours. Transferee requests after transfer to reduce hours under flexible working. Do they move to transfer 35? So they were doing their contract of employment for a full-time worker was 35 hours a week, so they would transfer, and those would be the hours that they would be expected to do once they're transferred across. So when you're looking at a flexible working request, you would be looking at reducing their hours from the 35 to whatever they've specifically requested. If that makes sense. Come back on us if it doesn't. You can query us. Right, I will crack on with fragmentation because, quite frankly, it's a bit complex. So it happens, as I say, it happens a lot, and I think it's happening more with the new sort of procurement rules where they're saying that you shouldn't be giving out massive contracts. You should be looking at splitting up the benefits in respect of that. So it often happens in situations where either the local authority is currently providing the service and then is splitting it into different service providers across the borough, or appoints different service providers for each area of the contract rather than one contractor providing the holistic service. It could be a situation where you've got they've got a situation where they've got a couple of service providers, and one working in the north of the borough, one working in the south of the borough. I did my hands the wrong way around there, and they change the way they're going to contract, and they're going to have 5 and they're going to work across the whole thing. So there's so many different ways that fragmentation can occur, and it does create complexity when assessing whether TUPE applies to the individual employees. So the main issue in TUPE is working out which employees of the current service provider would be eligible to automatically transfer, and if they are eligible to automatically transfer somewhere, where are they automatically eligible to transfer to? If you could pass me on to the next slide, please. So this is, as I say, this is one of these sort of issues that you often have to navigate. We call it fragmentation because the current services are splitting. And there are two things that you really need to consider on any situation. David's raised it previously, but we often have a situation that's written into local authority contract services agreement that says, there's assumption TUPE will apply at the end of this contract. And my view is that you should never assume TUPE will apply, because you need to determine that the services that are going to be provided are fundamentally essentially the same going forward. And as importantly, you need to be satisfied that the current provider has assigned a specific team to work on that particular contract, because if those two don't exist, then you don't have a TUPE situation, irrespective of how much work any one employee is doing on the contract. If they're not assigned to a particular contract to do this particular work, then they wouldn't transfer. If you could move me on a slide, please. So in looking at this, I mean, this is obviously setting out this just in a little bit more detail. So what the situation always was up until 2021, there was a case called Kimberley that everyone followed, which effectively said the purpose of TUPE is to protect the rights of employees when businesses change hands, or when their job is effectively moved to another supplier just by change of a contract. So it's about protecting employees' rights. And therefore, when looking at a situation where a contract fragments, so for example, you've got a care provider, and they're often a care provider or some sort of outsourced similar type of situation, and it's currently done in-house, and you're then going to you contract with 4 different providers, and then you have to assess whether TUPE applies, whether it's the same or similar services, and where people are assigned to. And Kimberley said that basically you look at the individual employees, and you should, the aim is to protect the employee's rights, and therefore the employee should transfer with the majority of where their work goes. And so this is where people got into the habit of looking at the TUPE information, staffing information that contractors need to send it in towards the termination of the agreement, and highlighting the percentage of time each individual spends on this contract. So there could be a general care team, and this, and you'll get the service information through, and it says everyone's spending 51% of their time on this contract. Because if the existing contractor loses the contract, then they've got a team of 20 and 50% of their time is spent on this contract, then they've got a massive potential redundancy situation. So they try and offload all those staff over to the new provider, which meant it's really difficult to ensure that that the contract was value for money, because how could a new provider take on all these staff where the contract only really covers 50% of their salary? They don't need the whole, every other member of staff. So it created a lot of issues. If you could move me on a slide, please. So we got to 2020 and we had this case in the European Court of Justice, ISS Facilities Services. And they looked back over what the purpose of TUPE was, and they said, that obviously the priority is to protect employees' rights, but you shouldn't do that to the extent where you're effectively creating uncommercial situations. And this was a situation where the employee worked across different the client owned different blocks of offices for cleaning, I think it was, and this particular person worked across some of them, 50% of the time on one of them and 50% of the time on the other. And the European Court of Justice looked at this and they said it is possible to divide a contract of employment between two separate employers as a result to ensure that the transfer is possible. So you're protecting the rights of the employee to continue being employed, doing their job, albeit they may have to do it for two separate organisations. But you can only do this, you can only divide the contract if it doesn't create worse working conditions or adversely affect the rights of the employee, those rights that are guaranteed under TUPE. So this is EU law, and it came in just before our cut-off time in terms of the Brexit rules, and it's obviously a fundamental shift in the idea of what you would do if a contract fragments. And if you can move me on a slide. So it has been looked at in the UK courts in the McTeer contracts case, and it's just worth looking at the facts a little bit, because this is a type of situation that you probably all recognise to a certain extent, in that you have a provider providing repair and disrepair to social housing, etc. And it was Amy, and they had two teams, and then they had an ops manager and a project surveyor who worked over both. And the teams weren't split so geographically, but they tended to work on their own particular team lot. So the aim at the retender was to they were going to split the contract between McTeer Contracts and Mighty, and they were going to divide them geographically. So Amy did an analysis of their staffing and worked out, looked at the geographical areas that each employee had worked over the previous 12 months, with the aim of allocating those teams across the two new providers. And because the ops manager worked only on this contract, but across both, and also the project surveyor, they allocated one to one lot, one to the other lot. And Mighty and McTeer disagreed that TUPE should apply and lodge claims in the Employment Tribunal, as did some of the employees, I believe. If you can move me on a slide, please, Medina. And the Employment Tribunal initially applied the analysis that Amy had applied and said, yes, this is fine. There is a TUPE provision change. It is everyone is eligible to transfer, and you can apply this analysis to that. And they all appealed on the basis that the Employment Tribunal had erred in assuming that each of the not the claimants, the employees must have transferred to either McTeer or Mighty. They didn't consider the position of whether each person individually to determine if it's possible to identify where their services transfer. Because going back to TUPE, you look at the individual, it's not a job lot here, so you have to look at the employee as an individual, and you have to look at whether TUPE applies, which is the service materially the same, and so you've got to work. So when you're looking at that question, if there's fragmentation, you've got to look at where those services are transferring to. So you've got to be able to identify the services that are existing there and where they go in the new lot. And that's the first sort of area of fragmentation. Can you identify where these services that are currently being provided here are going to go after the transfer? And the second is there a group assigned to those particular activities? Now, if the services are transferring, can you identify where each employee's work is going to transfer? Are they assigned to the particular activities that are going to be transferred to one particular organisation rather than they were assigned to it generically? And the EAT agreed, and they said they upheld the ISS facilities case, the ECJ case, and they said that an employee could hold 2 or more contracts of employment with different employers at the same time, providing the work attributable to each contract was clearly separate from the work of the others and was identifiable as such. So in this case, looking at this group of employees, they could basically transfer to each of the organisations for the percentage of time that that particular work would transfer if you could clearly attribute that work separately to each contract. If you could move me on a slide, please. They also didn't comment on the ISS facilities case, which basically said, sorry, there's a typo there, that when you're dividing a contract, where dividing a contract is impossible, so the situation where the dividing a contract would be to the detriment of the employees concerned. So where you can't do it, the contract may be terminated, but that responsibility for terminating it rests with the transferees. So you'd have a situation where new people are coming in, you as the client has decided to fragment this contract, you're going to have 4 or 5 new providers providing these services, and those new providers, because of how you've decided to do it, are somehow going to be responsible for the redundancy situation of the termination redundancy situation of the existing staff before they are their staff, and they can't transfer because you can't identify where they would go, or you can identify it, but it would make it too impossible for you to actually work it, make it feasible to work. And so it creates quite an impossible situation, and that hasn't really been commented on since. So it's sort of a watch this space in terms of how that is taken forward. And I suspect it probably will be one of those sort of arguments that are kicked in the long grass, because it would just make life far too uncommercial to try and make those suggestions. But the main takeaways from it here are: can you identify the activities that are transferring, whether they remain fundamentally the same, and where they transfer to? So if it's not possible to identify which activities have transferred and where, then it will be difficult to establish that TUPE applies. And can you identify an organised group of employees in respect of each potential transfer? So you have to identify where each activity transfers to, and then you have to identify if there's an organised group of employees that would be eligible transfer with that potential activity. Is there an organised group and the activities transferring can be identified, which employees are assigned to which transfer? And then you have to decide if the employees split across more than one of those. Is it feasible to do that? So is it feasible for them to have 2 contracts? Can they work their hours between them? And if not, you know, how do you manage that? Next slide, please. So it's not practical. I mean, it's a ludicrous situation. It's not practical in many situations to have 2 contracts doing the same work divided in that way, because unless you deliberately go out to get to 2 part-time roles, and then you as the employee are in control over the hours and how that works, this situation puts the employee and the employers in a really difficult situation. How you actually organise the hours, is there confidential information that you're going to get between both parties? A practical solution is to sit down with everybody and be pragmatic, sit down and have a consultation with the employees and say, this is happening. We have identified that the activities are the same. We have identified where they're transferring to. We think that your activities transfer 60% to this organisation, 40% to this organisation. Do you have a preference? Let's, you know, see if you can get to an agreement between all the parties. Let's all be adult about this and try and make it a way that is workable going forward. And that's, you know, that's possible if you've got three or however many organisations around the table who are willing to have that debate and don't want to just do the pushback on TUPE. The concern, or overriding concern, always is that you can have these agreements in place and you can make these changes, but you can't circumvent TUPE. TUPE applies by law, so it's automatic. So if there is a decision between the organisations, and for whatever reason someone is then subsequently dismissed, maybe redundancy, the organisation they go to have a restructure, don't need as many staff as then got in, that person could then say, but I had the right to transfer to both, part of my job should still be somewhere else. And so it is still a very complex area to cover. Next slide, please. I think this is Medina is going to cover this section.
Thanks, Julie. So stage transfers involve a gradual transition of employees where parts of the business are transferred from to different entities over time. For example, if a company were to sell its retail division to one buyer and its manufacturing to another, during these transitions, employees may experience a crossover period where they work for both the old employer and the new employers. This approach ensures a smooth transition while maintaining compliance with TUPE regulations, protecting employees' rights, and ensuring a continuity of service. There is a time frame, however, information about the transferring employees must be communicated with new employers, and this must be done within 28 days before the transfer date. This approach is often being divested in parts or when there is a need for a phased integration of a new entity. Moving on to the next slide. For a smoother transition of business, there are stages to consider. Firstly, there is an initial planning stage. This involves strategic planning by both the transferring and acquiring entities. They assess which part of the business will transfer and plan the timeline for each stage. Next is the employee consultation. This requires that affected employees are consulted and informed about the transfer. During this stage, employee representatives are engaged regarding any information about the transfer process, its implication, and any potential changes to employment terms are communicated with employees. Then we have the initial transfer. This is the first phase of the transfer, which involves moving portion of employees to the new employer. This could be a specific department, division, or location, depending on the circumstances of the transfer. Then we have the transition period. This involves where there is a crossover period between the employers who work for both the old employers and the new employers. This allows for a smoother transition and ensures the continuity of operation of the business. Finally, we have the final transfer. This is the remaining employees who are transferred to the new employer, completing the process. This may involve finalizing any outstanding administrative tasks and ensuring that all employees are aware of the new employment arrangements. A point to consider is that stage transfers offer flexibility and allows for a more controlled transition, mitigating risks and minimizing disruption to the business operations. However, it's essential for both employers to adhere to TUPE regulations at each stage to ensure and offer protection of employee rights and their continuity of service. This can be seen in the case of Housing Maintenance Solutions Limited and McTair and others, where the EAT found that the transfer of employees on the sale of a business or service provision changes takes place at a time where responsibility for the management of the business or service then transfers. Finally, if TUPE applies to the transfer of the business, transferring employees retain their continuity of employment and employee rights, and TUPE applies in two situations. These are where there is a transfer of ongoing concern, or there is a service provision change. For instance, a client engages a contractor to do work on his behalf, engages a different contractor to do that work in place of the first contractor, or brings that work in-house. Thank you. I'll now pass on to Julie for the final part.
Thank you, Medina. That was great. I think it might be a good time to answer a couple of the other questions before we go on, because the rest of it, just in case we run over. And I'm just trying to find the question, which I think is, as I say, is one of my bugbears. When you receive contractors' TUPE information, how can you challenge the information provided? So, as I say, we keep drumming on about it, but it seems to be forgotten often by contractors that are so used to just sticking everybody on their staffing list and assuming that you will accept it. So TUPE only applies if there is a group of individuals that are assigned by by the outgoing contractor to work on your contract. This is not a situation where there is one group, if they've got a staffing team that work on a number of contracts, you happen to be their major contract, that is not a group of individuals assigned to work on your contract. They're just a general staffing team providing those services. And so what you can do, you should push back if you have concerns that the information that they've given doesn't make sense. And the best way to do that is analysing the information. So if you look at what they've provided, and you work out the salaries that they've provided on those particular roles, can they actually employ those staff to work specifically on your contract within the contract price? That's one way of assessing it, and then you've got something very concrete to query. The second would be to speak to the project manager from your side and to work out who they know or works on it and what they believe how much they work on it and what they know about how the contractors team are organised, and then you question it from that perspective. You say, this is operationally, this is what we're aware of, this is what you tell us on an ongoing basis. And then the alternative option, it's potentially novel. We've tried it previously, but if you've got a contractor that provides the staffing information, as I said, they have like 50%, someone's working 55% on this contract and 60% on this contract, then you look at the McTair case that we referred to on fragmentation, that talks about fragmentation after the contract, and you apply, and you can if you look at the key principles for that, which is basically saying that that you can split a contract of employment between two employers, providing it's feasible to do so, and the two employers would then be responsible if it's not feasible to do so. And the purpose of doing that is to ensure that you don't have a situation where one employer has an uncommercial situation where they are having to take on a member of staff for full-time salary where they're only actually working, 60% of the time on this contract, and you apply that to this situation. You say, well, you have split your team. You are saying this team is specifically assigned to this contract, but only for 60% of their time. So only 60% of their time will transfer across to the new provider. And we'd then have to determine, depending on who the new provider is, if it's just one provider, it may be possible to assess what their work is and determine which work stays where it is and which work doesn't. If it isn't, TUPE doesn't apply. If it is, then you look at saying they're only transferring for that amount of time, and push back and see where you get on that. When I've tried it previously for a client, the incoming providers, people tendering, thought they were too concerned that it'd be risky, but wouldn't then tender, because the basis was that if they had to take on all these staff, the actual contract price didn't cover the salaries, and so sometimes I think you have to push back and apply the law in a way that it seems the key principles are. So that's what I would do. That's a really long-winded way to get there. Go on, David, you pop in.
I was just going to say there's also probably a good chance to answer some of the other questions that we received earlier as well. So one of them was the council has a main client and function being undertaken by company A, and they're going to be transferring to company B, and effectively what responsibilities, liabilities and issues could fall on the council if that goes wrong between these two people. So I mean, the main thing is the liabilities generally when you are moving from one contract to another are more likely to be commercial to the client, to the council, than it is employment liabilities, because you are not the employer that they're going through. You don't gain employment liabilities. But what we have been seeing is lots of risk-averse contractors basically going, if we have a problem with the ELI being wrong, or we've gained 6 employees that we weren't expecting, we now massively want to alter our tender prices because we've gained 6 people, so our costs need to go up. And this is, again, lots of scenarios where the council's supposed to be an information provider because you're the tenderer. And firstly, looking at your old contracts, are the clauses within there when you might have a TUPE scenario helpful to gain ELI information? I see a lot of the time going, oh, it's data protection, we're not going to provide it. You can still have some information provided that helps tenderers bid properly. Then the second is the contractual clauses on price change, making sure that those are suitable to, if there is changes in employment that employees coming across, that you are able to change the price, but have it as a negotiation rather than just the new contractor basically going, oh, here it is, we've now upped our price by an extra X amount a month, thank you very much, please pay this. And to make sure that the council or the tenderer is not suddenly adversely hit by a huge increase in costs. And that's generally where we're seeing it. And if things don't go planned between the two companies, I mean, ultimately, the employment issues are then between company A and company B. They don't land on the letting contractor because the service hasn't transferred through you. It's only in those sorts of scenarios that would happen. And then the next one was, if someone is transferring in, is offering harmonisation of terms. Now, harmonisation of terms in and of itself is not an ETO. It can never be an ETO. It can be part of why you are doing this. Harmonisation is not there, I think, deliberately to stop people from going, we're harmonising our terms, everything is going to be worse for you. And generally, changing terms because of a TUPE transfer is void. The changes will be void, and that's both positive and negative changes. There was cases a few years ago, directors knew a TUPE transfer was going, and they decided to give themselves massive pay rises. It was a positive change, they said, and the court went no, because it's because of the transfer. So that's part of the transferring in and consultation. You can look to offer them these new terms and change going forward. And then the risk of equal pay, not so much because you've got the material fact of defence. The reason they are on this pay is because of the automatic transfer principle. They have come in on this pay. You will have to honour that as part of the TUPE transfer. Now, what we have been seeing, or what I have certainly seen in the past, is where you have an opportunity to revisit that and then look at a consultation. And I have seen it where someone transferred from another local authority on better pay, and that there was a collective agreement that had better pay for a good long while. They then reached this, everyone else in the new local authority reached them and then continued to go because their new collective agreements uplifted them, and this person was left behind. At the end of that collective agreement, they used that as an opportunity to discuss with them and move them onto the new terms, and that was agreed and going forward from there. So that's where it can be done. But yes, there's also risks of that. But generally, equal pay is the material factor defence. If they transferred across on the pay that they are, because that's what their contract says or collective agreement says, you have to honour that because of the TUPE transfer. So Julie, do we want to move on to the examples quickly, because I see people are dropping off? So
yes,
get to the list there.
I'll just answer the last one because this first example I've covered. So if it's business, it really very much is fact specific, so it depends on the length of the project. So if there's short-term projects, then it's probably classed as a short-term project, and therefore TUPE doesn't apply. It very much depends. I have seen situations where they're short-term projects, but they basically run from one to the next, and there's just basically ongoing services, and they just renegotiate the terms and change a little bits, and it's the same people. It may be more complicated if that's the situation, but a short-term project TUPE shouldn't apply. And we've got another one. Can you utilise access control data to challenge the TUPE list? So you have no power to access their data, the outgoing provider's data. And I have often seen recently arguments by outgoing contractors saying we're not providing the specifics you've asked for the staffing list because it is a breach of data protection. So I think that's something you need to look at when you are drafting your contracts in the first place, to make sure the information that you're asking is generic enough that they're not going to be breaching anyone's individual rights, or that you require them to obtain consent from their employees to transfer that information at the end of the contract, something along those ways. If you can move me on a slide, please. Sorry, everyone, if you could just give me another minute. I think we've probably already covered this example, but it's a situation where there is a fragmentation. And it's a different type of situation. So the council changes the model from care contracts to provide these care packages to which have a guaranteed income, say £80,000 a year to provide these packages, to go into a situation where they're just going to spot purchase service from 10 different organisations. So a new person is referred to adult social care. Adult social care will assess that they need this full assessment, and then they will spot purchase that from a provider, and they may spot purchase each individual one of these assessments from different ones, or they may do it all as a package. I would say that is moving to a short-term model. It's a fundamental change in the way that service is delivered. There'd be no way of showing how that work is, how the activities that are undertaken now are transferring, because they're not, because there's no guarantee any work is going to any particular one. And in that situation, we would argue that TUPE doesn't apply. And as you can see, we are using terms, we would argue TUPE doesn't apply. We're saying TUPE may not apply. We're never saying TUPE will not apply, because only the tribunal can make that decision, and no one really wants to be in that position. So it's all about negotiation, really. If you can move us on to the last slide, please. Key takeaways. It's a minefield, isn't it, David? I think
Yes.
grey area. People go into it. Go into the consultation. You've got to get it right from the start. You've got to know what you're planning. You've got to inform and consult with your staff. You've got to think about if there are going to be any measures and be open and transparent about them. Engage with the unions, get people on board. And so they're the key things in terms of employees, because employees don't bring tribunal claims, and that's the only time anything goes wrong, is when employees bring tribunal claims. They don't bring employment tribunal claims if they're happy with it, and new providers don't reject TUPE if everything's transparent and clear cut, because if everything's transparent and clear cut, then TUPE will apply, and they'll know that that's pretty disastrous.
I was just I'll just add to that also when you're providing ELI and everything like that, do it quickly, do it promptly. The 28 days is the last opportunity you have to provide the ELI, and a lot of people say we won't have to provide it until 28 days beforehand. It's then got to be on that 28th day before the transfer, because employers are bringing claims for failure to provide ELI on time, and whilst it's potentially around 550, if not a little bit more per employee, if you're transferring a lot of employees, that's a multiplier that they will be asking you for. There's also then the issues of just next, or the tribunals can and will offer more because of what the damage for the lateness of this ELI has caused. And again, some contractors are being canny of like going, well, we didn't know about this, our operating costs are now changing, we want this amount of damages for the life of the contract. So you could be looking at a lot of money going forward. So don't sit there and wait for the 28th day. Yes, that's the last day you should be providing it. Doesn't mean you shouldn't be providing it beforehand. And again, it's that transparency, that openness, as Julie was saying. Happy contractors and happy employees don't bring claims, so don't try and leave things to the last minute if it can be avoided, because we have seen some of these claims going forward.
Thank you. We've got another couple of questions, so I appreciate people may have to drop out, and I'm sorry if we lose you. Our next session, we are going to cover some of the case law that's come out at the beginning of this year, so sort of a general update so far, and any that we missed from last year that we think should cover again. A lot of questions have come out of this session, and we're more than happy if we've got time at the next one, if you get the slides and you have some more questions, to come back to us. But if you have to drop out, then we understand it, but I can look at the questions that have come through now and answer them. So the next one is, we have a partner organisation, we carry out a number of different functions for them. For example, caretakers in housing blocks, they will be employing their own staff in some of these areas. So looking at that specific example, and I think you can't be generic when you're looking at TUPE, you've got to, because it's an individual's right to transfer, not a block contract. You can't block all your employees in one go. So if you currently provide caretaking services to an organisation and they've decided they're going to bring that service back in-house, you have to look at whether the service is fundamentally going to be the same, and whether you have a group of employees assigned to that service, then TUPE will apply, and they have to take those staff and then they have to decide how they deal with it. If they're going to subsume that work within the work of existing staff, then they have the redundancy situation, not you. And some seem clear TUPE like caretakers which work in those blocks. Is this fair? I'm not sure what. I'm sorry, I don't understand what that bit means. However, where we carry out other functions and it's not so clear, can you use the 50% working for that organisation, then potentially transfer if less than 50% no transfer? It's really difficult to advise on that, I'm afraid. I think we'd need to look at it in far more detail, because you need to analyse what is transferring and whether you have a group of individuals assigned to that. So if you have a generic team, so if you're the provider and you have a generic team that provides services to this organisation, and they have work that is transferring across, they may well argue that you don't have a team that are specifically assigned to the activities that are transferring. So it's not straightforward to say, oh, well, we'll transfer 50% of the staff across, because you look at them individually. If the individuals if they're in individuals' employment, so their services, some are staying with you, some are going, some are disappearing, it's something to factor in, but I think it's a bit too complex for us to try and cover vaguely at this stage. How do you evaluate cost application of TUPE transfer on a contract to be acceptable to be both parties? Gosh, unfortunately, I think if we could get an answer to that, we would solve all contractual negotiation disputes, I think. I don't think there is any straightforward answer to that, and I think it must be fact specific. But all parties be open to trying to reach a resolution, I would imagine. If employees transferring in work 40 hours a week and the employees in the new organisation work a standard 37 hours a week, should the employees who transfer in be offered the more favourable terms at 37 hours a week. They have a right to transfer in on their existing terms of service. They, as David set out, no one has the right, if you have more favourable terms for your existing staff, to say, oh, well, I want those terms now because I've come in. They have a right to come in on their existing terms and remain on their existing terms. The only thing that changes is the name of their employer. That is technically how it should work. It's up to you, therefore, if you choose to harmonise that situation. Some people would say it's a gesture of goodwill to ensure that they feel welcome and part of your organisation, that they would be integrated on the same hours, but then there may be other things that they have that are more favourable that you can't change. So that's a moot point, isn't it? I think that what is.
That was just two more have just popped in, so I think it's a continuation. That might have an equal pay issue, though. I mean, inherently no, because it's the automatic transfer principle. That is what they have come in on. That is what you were required to deal with. And again, with equal pay, you know, what is the reason for the difference? The reason for the difference is the TUPE transfer. It's the material factor defence. So, you know, certainly on transfer going forward, and it's like I said earlier, if you have opportunities to reconsider that and harmonise, and look, you might be chipping away at that defence because the tribunal might go, well, you had a chance to deal with that problem 5 years later and you didn't. You know, that's a bit of a time gap, but that's mainly what you're looking at. And then I think there's one more.
I think the other thing with equal pay is basically saying I am getting less pay for work that is the same work or equivalent because of my sex, and in this case the response is you may be getting less pay for the same work, but it's not because of your sex, it's because of a cheaper transfer. And I think that's effectively your defence to it. A client is currently providing a printing service in-house. The new proposal is to carry our printing off-site with the team only conducting emergency printing on-site with all of the work taking place. It may well apply. So I think you'd have to analyse what you class as emergency printing, how much that means. Have you got an organised grouping of employees? Are the services that are going to be provided essentially the same as the ones that are being provided now? And look into it. So it's indicative that it may well apply, that you need to look into it more, but we can't say for certain without having that level of detail. I think we've covered all the questions now. Thank you so much for everyone that has been able to remain on the session. If you've got any questions that do come up afterwards, please do get in touch with us. Thank you, David and Medina, for the presentation today. And unless anyone's got any questions, I hope you have a really good day. Thank you.